So this is Sedition. It whole Guwahati University syllabus semester 3rd LLB paper 3.1 Indian Penal Code. Yet unit 1 to my year belag video banam, but unit 1 to both easy. But general exceptions are also easy. Bhalko bujile to easy. Then unit 3 is which is offenses against the state and the public. Here brought my video banaiso unit point 3.1.1 that is waging war against the government of India, section 121, 121A, 122 and 123. He video to my English banaiso Assamese nahoy. So Assamese banabo lagile banam. Assaulting high officials to pisat banam. Now my the sedition or palta video banabo lagaiso sedition section 124A. Amar IPC or Guwahati University under 11 tarikhe exam ase IPC. So for this exam jone concept buja nai hihotor concept to clear koribole kane etu video banabo lagaiso. So ikhon IPC Mishra book, okay, tar pura moi hetu hol book or source to tar pura moi sedition part to scan korisu. So now I explain koribole goisu the definition. So sedition or first of all section to mana rakhibo lagibo, that is section 124 capital A. Capital A means etu amendment actor dora bhorwa goise, okay. Then sedition definition to prohibit goisu, whoever by words either spoken or written or by signed or visible representation jikono manuhe whoever jikone by words শব্দৰ দ্বাৰা শব্দটো হ'ব পাৰে মুখেৰে কোৱা শব্দ স্পকেন অৰ ৰিটেন লিখিত অৰ বাই সাইন অৰ ভিজিবল ৰিপ্ৰেজেন্টেশন নহলে সাইন বা সিন আই মিন গেস্টাৰ অৰ ভিজিবল ৰিপ্ৰেজেন্টেশন মানে যোনটো চকুৰ দ্বাৰা চাব পাৰি, ওকে, ৰিপ্ৰেজেন্ট কৰা হয়, ইনভলভস আইজ অৰ আদাৰৱাইজ মানে যিকোনো বেলেগ ধৰণে ব্ৰিংছ অৰ এটেম্পটস টু ব্ৰিংছ কৰে বা চেষ্টা কৰে attempts okay, attempts to bring hatred, contempt or disaffection. A word kita hatred, contempt or disaffection is important. Ekita keywords monat rakhiba. Towards the government established by law in India, towards government or proti established by law in India, or ekhon lawful government hoy, government or proti jodi কোনো by words either spoken or written or by sign or visible representation or otherwise jodi chesta kore brings or attempts to bring hatred, contempt, disaffection towards the government established by law in India commits the offense of sedition. Hedu kwa hoy sedition offense. So sedition offense to much similar defamation or nisina, okay. Etu English expression seditious label or logot similarity ase. Seditious label setu mane actually a kind of defamation to janat law of tort paisila sagoi. Then comes punishment. Yer kane ki punishment provide kora hoise. Punishment with sedition shall be punishable with imprisonment for life. First of all etu kotha mona rakhibo lagibo je life, okay, life holoke ase imprisonment for life or shorter term with or without fine or imprisonment, rigorous or simple, up to 3 years, with or without fine or with fine only. Section 124A. Comments expressing disapproval of government measures, sections on admissions without causing or attempting to cause hatred or disaffection do not constitute the offense of sedition. So life holoke dibo pare nahole any shorter period 3 years, life or 3 years eta mona rakhibo lagibo imprisonment hobo pare rigorous ba simple aru fine ase yar logot, okay. But comments expressing disapproval of government measures, sections or admissions without causing or attempting to cause hatred or disaffection do not constitute the offense of sedition. Comments jinbilage express kore disapproval, government disapproval mane agree nakora government or measure, actions or admissions mane government or policy or actions bilak jone agree nakore jodi to tar proti kiba ta comment express kore hetuk aru without causing, without means without চেষ্টা নকৰাকৈ বা attempt নকৰাকৈ any hatred, dissatisfaction আনিবলৈ কৰিবলৈ চেষ্টা নকৰাকৈ যদি এনে comment express কৰে এইবিলাক sedition নহয়, okay. Then explanation 1. The expression disaffection includes disloyalty and non-feelings of enmity. So yet আমি পাইছো the word disaffection. A word disaffection to explanation one not define কৰা হৈছে ইয়াৰ meaning কি. Disaffection means the expression disaffection includes disloyalty mane loyalty na hoy, distrustfulness and all feelings of enmity, and all feelings of enmity mane jikono dhoroner feelings mane hatred, ill will tenuka type feeling. Explanation 2. Comments expressing disapprobations of the measures of the government with a view to obtain disapprobation. Comment expressing disapprobations of the measures of the government with a view to obtain their alteration by lawful means. Yet a word to bhalke notice kora, obtain their alteration by lawful means. Alter korba bicharise government to when it change korba bicharise, but by lawful means. Lawful means ৰ দ্বাৰা তেতিয়াহলে হেতু sedition নহয়. This is all about sedition. So it is just definition of sedition. Case law add koribo lagibo. Okay. Yet our important was to note kora hobo je offense to kane punishment ki. Of course, we know that definition to provide kora hoise section 124(8) capital A. But what is the punishment? It will punishment on imprisonment for life. Okay. So batke besi punishment dibo paribo life plus fine. Kedaman keyword khale manat rakha likhibo pariba. Baki sentence to nije frame koribo pariba. Imprisonment for life and fine or imprisonment for 3 years. 3 বছৰ লৈকে imprisonment and fine or fine. আৰু এই offense ৰ nature কেনেকুৱা হ'ব? এটো cognizable হ'ব, মানে এটো serious kind of offense. Cognizable under CRPC. Non-bailable হ'ব, মানে bail is a matter of discretion and not right. Non-bailable, bailable নহয়. আৰু triable by court of session. আৰু এই offense টো court of session এ try কৰিব পাৰিব. আৰু non-compatible হ'ব, মানে এটো compromise কৰিব পৰা offense নহ'ব. So it's a serious kind of offense. যোনটো imprisonment up to life provide kora hoise. But ইয়াত একো provision mention নাই jo that or that penalty দিয়া যাব. It is the sedition, a kind of defamation. Into defamation or dore. Eta case ase. Here you see the constitutional validity of section 124A. Ekini Mr. Bukate bhalke dia asal but book kan scan nakorlo. That's why my internet search koribo lagia hoy ase. After the Constitution of India came into operations, and important questions relating to the constitutionality of sections 124A IPC vis Article 19 was raised in few cases, leading to a conflict of decisions in High Court. In Tara Singh versus State of Punjab, so a case to constitutional invalidity. Uprad question utha goisil Article 124A because it was sedition mane publication of hatred, contempt or disaffection against a government established by law in India. But amar yate Article 19 ase jonto hol fundamental right under part 3 of Indian Constitution. Article 19(1)(8) provide kora hoise freedom of speech and expression. Now the question here is e duta kiba conflict ot ase niki? Sedition to constitutional validity question utha goisil bahut case ot tare bhitorot one of the cases Tara Singh versus State of Punjab. Tara means star. Case to mona rakhibole kane bahut technique use koribo lage. Okay, mind map banaba lage and imagination nijor imagination to bahut enhance koribo lage, imaginative power do. So Tara means stars. Singh versus State of Punjab. Singh hekane State of Punjab. Okay, Tara Singh versus State of Punjab. A case to section 124 was struck kora hoisil mane down as unconstitutional boli koa hoisil, being contrary to freedom of speech and expression guaranteed under Article 19(1)(a) because of the freedom of speech and expression or against it ase jonto Article 19(1)(8) guarantee kora hoise. In order to avoid this newborn constitutional difficulty, the Constitutional First Amendment Act 1951 added in Article 19(2) in terms in the interest of justice and public order, thereby including legislative restrictions on freedom of speech and expression. But at a time important man koribo lagia je Article 19(2) reasonable restriction provide kora hoise freedom of speech and expression or jonto Article 19(1)(8) provide kora hoise freedom of speech and expression. Aru etu Article 19(2) jono reasonable restriction se hetu hobo pare in the interest of justice or public order bahut ase sovereignty integrity of state. But apart from this yat korate important case hetu hol Supreme Court in but ইয়াৰ আগৰ কেছটো Tara Singh versus State of Punjab এই কেছটো Article sections 124(a) টোক unconstitutional বুলি declare কৰা গৈছে as being contrary or inviolative of Article 19(1)(a) of the Indian Constitution. But another case আছে Kedarnath versus State of Bihar. এই কেছটোত এটা different opinion দিয়া গৈছে. Kedarnath versus State of Bihar. Okay, Kedarnath versus State of Bihar. It is state hoy Bihar. Aru manujoner naam hol Kedarnath versus State of Bihar ruled that section 124(a) IPC to be intravirus. Intravirus means junto ultravirus nahoy, mane unconstitutional, invalid, void or inoperative nahoy. Intravirus of the constitutions. The court held that any law which is enacted in the interest of public order may be saved from the vice of constitutional invalidity. The right granted under Article 19(1)(a) is subject to such reasonable restrictions as will come within the purview of Clause 2. কিন্তু এটা মন কৰিবলগীয়া যদিও Article 19(1)(a) freedom of speech and expression দিয়া হৈছে কিন্তু ইয়াৰ reasonable restriction provide কৰা হৈছে Article 19(2). With reference to constitutionality of Section 124A of the IPC as to how far they consistent with the requirements of Clause 2 of Article 19, with particular reference to security of the state and public order, particular reference to security of state and public order. The section penalizes any spoken or written words or signs or visual representation, etc., which have the effect of bringing disaffections towards the government established by law in India, has to be distinguished from persons for a time being engaged in carrying on the administration. That government established by law is visible symbol of the state. The very existence of the state will be in jeopardy where the government established by law is subvert. So accordingly ইয়াত কিছুমান Article 124(8) কিছুমান explanations provide কৰা হৈছে যোনটোত কোনটোৱে sedition amount কৰিব আৰু কোনটোৱে sedition amount নকৰিব তাক expressly provide কৰা হৈছে. For example, governmentor যদি as already পঢ়িছিলো, as already we have seen here that yat talatwa swada expression disaffection includes disloyalty and feeling of enmity, but comments expressing disapprobations of the measures of the government action policy measures proti comment express koriba pare moi beya paisu moi disagree korisu disapprobations mane hetu with a view to obtain the alterations aru etu eta object da hetu kora object by view hol je government alteration bisare bane change bisare beleg eta government ahatu bisare by lawful means aru etu lawful or peaceful means. That's why it is not an sedition. So yet যদিও offense define কৰা হৈছে কিন্তু কোনটো বস্তু sedition amount কৰে আৰু কোনটো বস্তু sedition amount নকৰে হেখিনিও দিয়া গৈছে এই sections টোত inserted by certain amendments or জৰিয়তে. Then let's see here history of sedition laws in India. The most celebrated cases of sedition law arose under the British colonial rule. British colonial rule law under sedition or cases both will I say and against the freedom fighters or hebrew against freedom fighters because freedom fighters of course government British government to alter koribole bisarisil. In 1897 Bal Gangadhar Tilak was booked for sedition. We know history book of Bal Gangadhar Tilak. His speeches seem to have provoked violent behaviors of others. As a result their speech bilake belagor provoke korise violent behavior belagor obrot provoke korise. As a result British officials lost their lives. Lost their lives. He was convicted but released on bail in 1898. Convict kora hoisil but akote bail dia hoisil in 1898. In Emperor versus Mohandas Karamchand Gandhi and Shankarlal Ghilabhai Shankar. Gandhiji being the editor of the paper Young Indian, Gandhiji Young Indian number paper khonor editor hoisil along with Shankarlal Ghilabhai Shankar printer and publishers were charged under section 124A for bringing or attempting to bring hatred or contempt or exciting or attempting to excite disaffection towards his majesty's government established by law in British India. So hegeni garne sedition under charges letwe case to by means of the written words are spoken nahoy contained in the article tampering with loyalty. Our article 2 heading to some tampering with loyalty 29th September 1921 and the puzzle and its solutions 15th December 1921 and shaking the mast 23rd February 1922 published at Ahmedabad. He was sentenced to 6 years of simple imprisonment. They have sentenced for attack sentence punishment dia hoisul 6 বছৰৰ simple imprisonment. এটো হল পুরানা কেস ইয়াৰ পৰাটো কিছুমান নতুন কেসো আছে seditionৰ নতুন আপডেট current affairs আছে. কেছৰ নাম হল Emperor versus Mohandas Karamchand Gandhi. We all know that Gandhiji is here emperor her plaintiff or defendant hol Mohandas Karamchand Gandhi. Gandhir full name আৰু তাৰ লগত আৰু এজন মানুহ আছে Shankarlal Ghilabhai Shankarlal Ghilabhai Shankar. That's it, naam to easy monor kibole. Then section 124 vis-a-vis freedom of speech and expression. We already read the constitutional validity ki ase, right? Okay, position in the United States I think it dorkar nai position in Malaysia iman kine dorkar nai but section 124 vis-a-vis freedom of speech and expression. Article 91 secures every citizen's right to freedom of speech and expression. Article 91 is a right to freedom of speech and expression. It junto include kore freedom of press also. Freedom of speech and expression include kore freedom of press. Press mane ki press mane media freedom ase yar dara media opinion will express correct, right? Media is considered as the fourth pillar of democracy. It means the right to express one's convictions and opinions freely by words of mouth dara, habdor dara, writing, printing, pictures, লিখাৰ দ্বাৰা প্ৰিণ্টিং কৰাৰ দ্বাৰা পিকচাৰ্ছৰ দ্বাৰা এনি আদাৰ মোড আৰু বা যিকোনো ধৰণৰ মোড দ্য ফ্ৰীডম অফ স্পীচ এণ্ড এক্সপ্ৰেছন ডাজ নট কনফাৰ নম্বৰ 1 এন এবছলিউট ৰাইট টু স্পীক অৰ পাব্লিছ এবছলিউট ৰাইট নহয় মানে সাবজেক্ট টু ৰিজনেবল ৰেষ্ট্ৰিকশ্যনছ ৰিজনেবল ৰেষ্ট্ৰিকশ্যন ক'ত প্ৰভাইড কৰা হৈছে আণ্ডাৰ আৰ্টিকল 19(2) an absolute right to speak or publish without responsibility whatever one may choose or to an unrestricted or unbridled license that gives immunity for every possible use of language etu nahoy je jikono dhoronar kotha koboloi ba speak koribole ba publish koribole ek responsibility na thaka koi jikono june jeneke bisare ba etu enuka nahoy je unrestricted ba kono dhoronar restriction nai ba unbridled license etu kono dhoronar unrestricted license dia nai juntu community for every possible use of language 3 does not prevent punishments for those who abuses this freedom aru wake up jeta freedom dia jay tar misuse thake abuse thake so heavy abuse or misuse bilaku prevent koribo lagibo ekane tar karone provisions under article 19(2) say does not prevent punishments for those who abuses this freedom clause 2 of the article list the grants on which the freedom can be restricted clause 2 of article 19 that grant bilak likha ase bear act pohile grant bilak pai jaba so grant bilak diba lagibo ne এটা কেটামান কেস দিলো ইয়াৰ পৰা নতুন কারেন্ট অ্যাফেয়ার্স কিছুমান কেসও আছে It was a heading 5 landmark cases that changed the way we look at Indian seditions. My internet পৰা লৈছো আৰু মই descriptions to দি দিম YouTube or description listed বা comment section মই link to দি দিম okay জৰ পৰা মই লৈছো India's law regarding freedom of speech has gone through a fair amount of changes over the years right from the inception of Indian Penal Code 1860 The arrest of JNU student, JNU Jawaharlal Nehru University student leader Kanhaiya Kumar, etu nitun current affairs on charge of sedition inciting violence through unlawful or anti-national speech or karne illegally creating webs not only across India but internationally as well as students, teachers and academians towards world over speak out in support of JNU students and against their treatment by the government. So etu kesot ki asil Suhrit Parthasarathi an advocate of at the Madras High Court who's also working on a biography of the Supreme Court cited the law regarding sedition section 124A of the IPC in this article for the Hindu their article for the Hindu as it reads today sedition is defined as any actions whether by words, signs or visible representation it brings or attempts to bring into hatred or contempt or excite or attempt to excite disaffection towards the government established by law in India. Same. The law was passed part of the original IPC drawn up by Thomas McKelvey. IPC to drawn korise kone Thomas draft korise kone Thomas McKelvey korise but was dropped when implemented in 1860 only to be reintroduced citing the initial omissions to be a mistake a decade later left ambiguous okay after that left ambiguous and vague the law of seditions came to good use for us country's rulers as a method of crowd control in a way open to ambiguous interpretations with an added clause it was used to famously smack down dissenting Bal Gangadhar Tilak and later prosecuting Mahatma Gandhi in 1922 seditions 124A under which I am happily choice is perhaps the brains among the politicians. Okay, sections of IPC designs to suppress deliberative dissent. Said Mahatma Gandhi response to a charge against him, and he could not have been more correct. So Bal Gangadhar Tilak and Mahatma Gandhi duta case ase kita to dilo. Aru Kanhaiya Lal notun to current affairs. Okay. After his already case ase Queen Empress. The Queen Empress versus Bal Gangadhar Tilak 1897. It बहुत पुराना case. This is a man Bal Gangadhar Tilak, I think. So perhaps the most famous case of seditions in history have been of our country's freedom fighters. Our country's freedom fighter case against colonial rule. Bal Gangadhar Tilak, a staunch advocate of Indian freedom, was charged with sedition. The sedition offencer lagot charged cecil on 2 occasions to the occasional charged cecil. Someone expressly knockout of you. It was an example. The private counsel in regard to the culprit persons have been charged with sedition. Okay. সেইখিনি লিখিবা কেদাৰনাথ সিং ভাৰ্চেছ ষ্টেট অফ বিহাৰ এটো লিখিলো এটো ল্যান্ডমাৰ্ক এণ্ড সো কনস্টিটিউশনাল ভ্যালিডিটি ভ্যালিডিটিৰ ওপৰত কোৱেশ্চন উঠা আছে বাট কনস্টিটিউশনালি এটো ভ্যালিড দেন ডক্টৰ বিনায়ক সেন ভাৰ্চেছ ষ্টেট অফ ছত্তীশগড় পঢ়িব বিচাৰিলে পঢ়িব পৰা মই লিংকটো তলত দি দিম Assam Trivedi versus Asim Trivedi versus State of Maharashtra. Okay, this was also in case cartoonist Torprod, controversial politician, cartoonist and activist Asim Trivedi, best known for his anti-corruption campaign cartoons against corruption, was arrested and charged of sedition in 2010. Then Sriya Singhal versus Union of India. The Kikurisal, this case is monumental Indian jurisprudence as its judgment took down section 66A of the IT Act sought to be in violation of Article 19 of the Constitution. Okay, current affairs যদি পঢ়িব বিচাৰে তেতিয়াহ'লে এড কৰিব পৰা তাৰ লগতে মই তিনিটামান কেছ লিষ্ট আছে সেডিশ্যনৰ ওপৰত বিচাৰি পেলাই বিকজ মই মিষ্টাৰ বুকখন স্কেন কৰিছিলোঁ এই পাৰ্টটোত চ' আই হোপ ইউ লাইক মাই ভিডিঅ'টো যদি ভাল লাগিছে দেন প্লিজ ছাবস্ক্ৰাইব কৰিব আৰু শ্বেয়াৰ কৰিব আৰু যদি বেলেগ কিবা ভিডিঅ' বনাব লাগে IPCৰ ওপৰত বিকজ 11 তাৰিখে ইণ্ডিয়ান পেনেল কোডৰ এক্সাম আছে ৰাইট চ' তাৰ কাৰণে পঢ়িব লাগিব কিবা হেল্প লাগে যদি মই এইটো আই থিংক 20 মিনিটৰ ভিডিঅ' বনালোঁ বহুত লং ভিডিঅ' যদি মই বেছি ফাষ্ট কৈছোঁ তেতিয়াহ'লে ভিডিঅ'টো তুমি প্লেবেক স্পীডটো কমাই ল'ব পাৰা অ'কে আৰু ছাবস্ক্ৰাইব কৰা আৰু মোৰ ভিডিঅ'টো শ্বেয়াৰ কৰা এণ্ড ফিডবেক দিয়া কনষ্ট্ৰাক্টিভ ক্ৰিটিচিজম দিব পাৰা থেংক ইউ